I never liked losing, whether to a senior experienced counsel or to a bright young counsel, but I must say I admire meeting a young, bright counsel who whips my ass. If I gotta lose, I'd rather lose to someone like that. There's so many bright young counsel coming along. One of them has just left Faskins to start a new career with its spin-off, Kelly Affleck, Melissa Kennedy.
Well, it's a great honor for me to be included on today's program. By no means include myself with the level of counsel that has been speaking today, but I can guarantee you I've spoken to a number of senior counsel and their thoughts of pretrials, and include their thoughts in my presentation today. Pretrials, the emphasis I'm going to be making on today is pretrials as a way in which to try and get the facts cheap and quickly. Unfortunately, pretrials are not used in this manner very much by counsel. The types of pretrials that we have in Ontario are of three different types. There's a case management type of pretrial, which I won't be talking about, and there's also the mini trials that counsel can be involved in a pretrial. They are very effective. I talked to counsel who've been involved in mini trials, which can end up with days and days of basically a small trial within a pretrial, and the matter is then settled. What I'm going to be focusing on today is the pretrial that is envisioned by Rule 50 of the Rules of Civil Procedure. And particularly, I'm going to be talking about what can be done in pretrials, but unfortunately what is rarely done in pretrials today. They are an invaluable tool for us to try and get the facts cheaply and quickly, and to save our clients an enormous amount of money in trial preparation and at the trial itself. The background of pretrials is reflected in the policy. The pretrial concept was introduced in Ontario in 1978, and it was introduced as a means to save resources, both of the court and of the client, and of course of counsel's energy and time. The two aspects of the pretrial concept in Ontario were, one, to encourage settlement, thereby preventing trials at all. I won't be focusing on that part of pretrial today. The second part of the policy behind pretrials is to force counsel at an early stage to understand the case, thereby shortening the time necessary to be spent at the trial itself. It is this particular aspect that can be crucial in getting the facts out quickly and cheaply, and saving an inordinate amount of time, money, and effort that needs to be spent. Fortunately, pretrials are underutilized. They are thought of as sometimes simply as a vehicle for settlement negotiation before an independent third party, a means by which number crunching occurs. You go into a pretrial and you ask what types of settlement offers have been made. They come out on the table and they have a little bit of discussion what the case is about. Can we get instructions on this? You go away and 25 minutes is over, and that's the end of your pretrial. Even worse, sometimes the pretrials are thought of as just simply a necessary rule that must be satisfied. In a lot of jurisdictions, such as Toronto, you cannot get a fixed trial date unless you attend the pretrial. So sometimes we look at pretrials can be looked at as simply being a necessary evil in which to obtain a fixed trial date. I suggest that the reason for this is because there are no sanctions. Unlike the problem if we do not use our pleadings or our discovery processes properly in order to get the facts out, there are no sanctions if pretrials are not properly utilized. If perhaps there might be at a later stage, counsel might spend some time in using pretrials to a better effect. But in any event, there is no sanctions at this point in time. If you look at Rule 50.01, there are explicitly stated in the rule 9 means for which the pretrial is to be conducted. And 4 of them relate particularly to what this program is about. There is a final one, it's the basket clause under 51.01J, which basically says any other matter can be considered in a pretrial. But the four that I'll be focusing on today are B, C, D, and E. And in B, it specifically states that the judge at the pretrial conference is to consider the simplification of the issues. That's exactly what we're trying to discuss here today. In order to simplify the issues, however, we've got to know what they're all about. And I'll discuss later on how we can get to that stage when we know what they're all about. In the meantime, you've got to abandon the kitchen sink approach. I think as young counsel, sometimes we go into a case and we're afraid to simplify the issues. We're afraid to look at a case and say, okay, I really don't need this. Our inexperience leads us to the conclusion that everything's got to be thrown into a case. Unfortunately, that works to our detriment because you're not going to be thanked by the trier of fact at the end of the day who has listened to every single possible angle of the case, which many of times is completely irrelevant. 90% of cases turn on very few factual issues. It's almost impossible at the beginning to figure out what each particular factual issue is that will be crucial in the case, but we can certainly narrow it down more than we usually do. So abandon the kitchen sink approach and try to get down to those few issues that will be crucial to the case. Both the legal and the factual issues can be simplified, and I know this program is about factual issues, but the legal ones can be simplified too. A lot of times there are many legal issues that are thrown in and they're peripheral. They're not central to your case. How to simplify the factual issues. This can be done through concessions that you make on behalf of your client, of course with instructions, or that you get the other side to make, either through agreement or by forcing the court to make orders at the pre-trial stage. The pre-trial judge is able to make such orders, and if you know what concessions that you want from the other side, you can get the pre-trial judge to make those orders if they're not forthcoming. The idea of getting concessions or getting admissions at the pre-trial stage is specifically included in Rule 50.01 sub C. And it specifically states the possibility that the pretrial conference is to consider the possibility of obtaining admissions that may facilitate the hearing. 50.01D discusses the question of liability. The pretrial judge is to look at questions of liability, and once again, these of course turn on the facts. You've got to know what your facts are that are key to the issues of liability. 50.01E looks at the amount of damages. 99% of the cases, these also return on specific facts that you need to know in order to, once again, simplify the issues. The basket clause refers to any other matter that may assist in the most just, expeditious, and least expensive disposition of the proceeding. Once again, the whole point of a pretrial is to shorten the trial, hence getting the facts quickly and cheaply. There are a number of orders you can obtain in narrowing the issue. You can ask for an order that gets production of documents. It may be that you look at the pretrial stage and you realize you don't have all the documents that you need from the other side. Ask for an order for the other side to produce those documents. You can bring a motion, but there's no reason why you can't do it in the pretrial stage. The pretrial judge has a jurisdiction. Pretrial judge can also order that undertakings be answered and determine the appropriateness of refusals. Pretrial judge can also compel the production of expert reports. Now, it may be that at the pretrial stage, you ask for these particular orders. You realize that you're going to get more documents, more productions, maybe more experts' reports, and therefore more information. So it's impossible in the first pretrial really to narrow the issues because you don't know what all the facts are going to be. You can request from the pretrial judge to have a second pretrial or a continued pretrial at a later stage once you get all the documents and productions out. The judges are very amenable to having you come back before them again to continue to talk about narrowing the issues and also for settlement purposes. So if you think you need more time before that particular pretrial judge, it can be done. It also is invaluable because you don't need to then go to a second pretrial judge or a second trier and explain your whole case again. They understand, they know what the issues were, they'll have heard the squabbling, if any, between counsel, and they'll realize, okay, production has occurred, now let's get down to brass tacks and figure out what are the issues that we can narrow in this particular case. Too often, we underutilize a pretrial conference, and quite often that's done by the person who is asked to prepare the pretrial conference memorandum, has not attended any of the discoveries, doesn't know anything about the case, and is simply asked to, here's a pretrial memo that needs to be done by next Tuesday, and you do a competent job, no question. The problem is you're not utilizing the pretrial as it is meant to be done. All you're doing is simply satisfying the rule on behalf of your client. You're not using the pretrial to try to get out the facts quickly and cheaply and to save your client some money. Sometimes the memorandum is prepared hurriedly. There is a memorandum, which everybody's seen. I didn't include it because we've all seen it, and there's no magic to it. This is simply a minimum checklist or ideas of things that should be included in a pretrial. This is not the maximum. Unfortunately, too often this is used as the blueprint for what the pretrial memorandum should contain, and there are so many other things that it can contain. For instance, in the section marked admissions, there is a admissions, and too often, how many times do you see nil? That often is a reflection that not a lot of thought has gone into an analysis of the case, and we'll just put nil so as to keep all of our ducks in a row, and we'll think about it later. Well, later is at the trial, and the trial may happen in a few months. So my suggestion to utilize pretrials more effectively is let's think about it now. Trial starts to come up. You've got witnesses you've got to get together and scramble together. Quite often they haven't been contacted for some time. You've got to keep your client client happy. They're becoming extremely nervous about getting into the witness box. You've got all sorts of productions to get together. All of your productions should be on computer. They may not be. You may be scrambling to have your clerks put them on computer. And at that point in time, the last thing you need to be doing is to then looking over the admissions and request to admit and all those sorts of things. Those are exactly the types of things that can be handled at the pretrial stage, because there usually won't be many things that will come out later. It makes a lot of sense, I think, to do as many things at the beginning in preparation for trial than squashing it all in right at the end, and everything is completely frantic. So my recommendation is when you're thinking about how to attend a pretrial, you need to have an objective. What am I trying to prove in this pretrial? If you're simply trying to get a fixed trial date, then fine. You simply need to fill one of these out, attend, not looking competent, and you'll get a fixed trial date. However, you've completely missed the point. You've got to have an objective. What am I trying to do? And therefore, in order to have your objective, you've got to understand your case. You may want to understand what facts you need to prove on the issue of liability. What are your issues of liability? Same type of analysis needs to occur on the issue of damages. You may want to make some admissions with instructions from your client that will simplify the matters. Are there any admissions that the other side has already made in examinations or through its documents? For instance, as Trish Jackson was saying in her presentation, you may have such a wonderful record in the examination for discovery of those nice admissions. Is there admission through the transcript of the examination for discovery that you can get out at the pretrial stage? That'll save you some time at the trial and save your client some money. Are there admissions that the other side will properly make that can be inferred from the documents, the transcripts, the reports? These are not explicitly made, but perhaps implicitly made through the documents. Request to admit must be served 20 days before trial. There's a pretrial judge right there who can make an order. Why wait the 20 days before trial when all hell is broken loose probably on many other things in your trial? Try and deal with those issues at the early stage, and a pretrial is a wonderful time to deal with them. On the issue of documents, what documents do you need to prove for your case? You should be thinking about that at the pretrial stage. What documents need to be formally proved with the notices under the Evidence Act? What documents are you going to be required to formally prove by your opponent? Is your opponent going to be a stickler and ask for formal approval? If you think that's going to be the case, raise it as an issue at the pretrial stage, have it out before the pretrial judge, who can then make an order, so you don't get into some nonsense 2 days before trial when you've got far too many other things to think about than to try and whip up the witnesses necessary to formally prove some very basic documents. If you think that nonsense is going to start to occur, raise it as an issue at the pretrial. Or even if you don't suspect it's going to occur, get it on the record before the pretrial judge, who can make an order for you. Do you have all the necessary documents from the other side? You may not have had all your production. It's very common. Best of all possible worlds, you will have had your production, but that may not be the case. You may need an order from the the pretrial judge. Similarly, have you produced everything? And if you haven't, a pretrial is a good time to produce it, as opposed to a few days before trial when unwittingly you realize, oh, I forgot to send those documents over, they're not that important, and then you may get slammed on costs later. If you produce them early rather than later, you can save that argument on the cost issue. With respect to undertakings, have they all been answered? Are there any refusals that you still want to take issue with? Are there any refusals you don't really care about? Has your client made refusals that you figure now can be properly answered, or you still want to stick to your guns? Have you considered all the matters taken under advisement by both your client and the other side? You don't want to be faced with a silly little nitpicking point at trial about, oh, well, we never got the answer back from the other side. It was taken under advisement, and if you had 15 minutes to clearly think about the issue, you would have realized you could have provided the information to the other side. On experts' reports, are they necessary in a particular case? On what issue? Have they all been produced? And if they have been produced, has your expert seen the other side's expert reports? So you can have an analysis of the persuasiveness of the experts' reports. That should occur at an early stage, at the pretrial stage, because there may be some facts that come out of that analysis that you need to get in order to simplify the issues. Has the other side indicated in discoveries or in correspondence that they will be retaining experts, but have yet to do so? The 10-day before trial notice is not kindly looked upon in a particularly complex case. And so at the pretrial stage, you may wish to point out to the pretrial judge, they've been indicating we're going to have an expert on this aspect of damages. We've still yet to see it. You know, I don't want to see it 10 days before trial. The pretrial judge can make an order, must be served at least 90 days before trial or within 30 days of the pretrial, whatever. That gives you some leeway. There are very few cases about pretrials, but there is one in particular with respect to the production of expert reports at the pretrials. In Fungal and Fallis, Mr. Justice Eberle of the High Court at that time ruled that you had to produce what you had at that date at the pretrial and provide it to both the pretrial judge and to the opposing counsel. You can't just pick and choose, and you can't just give it to the pretrial judge. It's got to go to opposing counsel. Some counsel have concern that they're going to be, you know, opening all their books to the other side. Well, that is the entire point of the pretrial. And there is a case now of the Supreme Court that says everything you've got as of the pretrial date must be disclosed to both the judge and to the opposing counsel. That does not, however, preclude you from producing further expert reports. So if you do retain an expert later on, you can produce that report. However, Mr. Justice Eberle made it quite clear that you cannot, that the court will look very unkindly upon counsel timing the production of the expert reports so as to avoid their production at the pretrial stage. He stated that a deliberate attempt to scuttle a pretrial conference by delaying the receipt of experts' report would, in my opinion, be inconsistent with counsel's role as an officer of the court. Therefore, I caution you against using that because it seems to be, and rightly so, not looked upon favorably by the court. And it completely undermines the whole point of pretrial and the openness of the court system currently. Once you have all of these, you've considered all of these things, you need to then figure out, how do I accomplish the particular goals I'm trying to seek in each case? Well, my recommendation to you is prepare for the pretrial as you would for trial. Now, that's a completely long way away from taking this 4-page document, ticking off a few things, and you're done in 2 hours. It can be done. You can get these things done in 2 hours. But if you want to be effective at a pretrial and actually do some shortening of the case for your client, you need to prepare for the pretrial as you would for the trial. You've got to review all the productions, both yours and theirs. You've got to review all of the transcripts, examinations for discovery, the cross-examinations, co-defendants, and you've got to look at it all. You've got to review the pleadings and any orders from any interlocutory proceedings, because they may affect what particular facts you want to prove. I recommend reviewing the correspondence. There's sometimes things contained in the BRAD which lead you to point out to the pretrial judge that certain admissions have already been made, implicitly at least in the correspondence. And of course, you've got to review any of the expert reports that you've received from both your own expert and from the opposing side's expert. You've also got to meet with your client. And now that's not often done either, because pretrials are unfortunately not looked upon as being as useful as they can be. But if you meet with your client, you're then in a position to get the proper instructions. You can sit down with them and say, listen, at the discovery you made this admission, I want to make this admission here at the pretrial. It's going to come out in the trial anyway. Do we have your instructions? And you can give advice to your client as to on those particular issues. You want to meet with the experts. Provide the experts, as I was saying, with the other side's expert reports to get an idea of the experts, what other facts may be necessary, what facts can be conceded. And you, if best of all possible worlds, you want to meet with your witnesses. Again, a view to figure out what the issues are and to try and narrow them. The pre-trial memo, I think, is one of the most important documents at the pre-trial. Unfortunately, as I was saying before, it is too often viewed simply as a checklist. But the material that you put in your pretrial document is key. The goals of the pretrial are two: to provide a background of the case so the judge has an understanding of what's going on, and also to provide other material to persuade both the judge and the other side as to your position if you're trying to get admissions on the record. When providing the background information, make it concise of the relevant facts. Provide a compendium of the relevant documents. Compendiums used in commercial court, and it's insisted upon there. I think it should be used in the civil court or the general division, at least at the pretrial level. A compendium is the relevant documents highlighted, the specific passage, not the entire contract, but the particular passage that is an issue. Passages of the transcripts that are an issue, perhaps correspondence that help establish what the case is about, and if necessary, a few cases of law. For the goal of trying to persuade counsel and the judge as to your position, I would provide a list of the admissions that you want from the other side, and provide a list of the admissions that you're willing to make. Set out a index of the document brief that you want the other counsel to agree to. You've got to make up a document brief at any event before trial. There's no reason why to wait 2 days before. You know what the documents are, generally speaking, so get them out at the pretrial stage. And set out any necessary materials that you need to obtain the orders that you want sought. For instance, if you're trying to compel undertakings, prepare a motion-like record for the pretrial judge to look at, so that he or she can make the appropriate order to compel those undertakings. The attendance at the conference, I think, should be made by the person who has the instructions of the client and knows the case. That seems pretty academic, but that is not often the case. It may be beneficial to have the client either nearby or at least accessible by phone if you want to try and get instructions to narrow some of the issues. In conclusion, I think it's up to us as counsel to try and make the pretrial conference more effective than it is currently being used. As a tool for trying to get the facts out cheaply and quickly and to save our clients money, which seems to be the thrust these days, it is absolutely invaluable. Unfortunately, I don't think that it is being used as well as it could, and I think it's up to us, together with the bench, to try and turn this particular step in litigation around to become more useful. Thank you.
I'm a fan of pretrial. I think You can settle at pretrial. You can narrow the issues at pretrial. I'd like to see more use of early pretrial to try to narrow the issues after pleadings before you get into complex, lengthy discovery. Largely a problem of not having enough judges to staff that kind of pretrial, but I think it's desirable. The courts exist to resolve disputes. Disputes are resolved by settlement as much as by trial, indeed more so. Chief Justice McClure used to have the opposite opinion. He wouldn't hear settlement discussions, didn't think it was a judge's job to talk about settlement. Judges were there to try cases. Wouldn't call you into chambers, wouldn't knock heads. I'm here to try cases. At the opposite end of the scale, all the trial judges will tell you that the settlingest trial judge is our next speaker, the Honorable Mr. Justice Lissaman. If you want to get a case settled, if you want to get a case shortened, somehow try to wangle your way before him. Mr. Justice Lissaman.
It was just wonderful to hear from the sidelines someone talk about the merits of pretrials. Thank you very much. I've been a believer of pretrials before they were done. In fact, I believe that I have conducted or participated in pretrials before officially they were even identified. And Harvey Bliss is quite right. In the old days, we did have judges, wonderful judges like J.C. McClure, who, and I mean that absolutely sincerely, and I knew him quite well, who had a definite view about a judge's role. And as the years went by, then we had people like Mr. Justice Edson Haynes, who invariably would be a settlement discussing type judge. And some people liked his technique, I was going to say tactics. Some didn't like it. I remember quite a well-known judge who was a lawyer for a good number of years saying to me one day on the street, he said, "That's the last time I ever go into his office willingly." Well, he still used to go in, but he didn't go very willingly. I have several roles on the bench. I'm a case management judge, as some of you know. I'm also a team leader, team 4. That means I have approximately 25% of the civil list. I quite enjoy that role. I have two kinds of cases that cause me a great deal of trouble. The small cases, the $4,900 cases, often commercial, and the long civil jury trials that are invariably personal injury. And we're going to talk a little about them in a few minutes. I've certainly enjoyed what I've heard the last few minutes. I'm wondering what kind of techniques Harvey Bliss will have to talk about as to how you deal with a small case, because everything I ever hear when I come to conferences is to how to deal with a big case. Well, one of the most important things that lawyers have got to learn to deal with is how to deal with the small case, and I mean that sincerely, because I see lawyers, particularly from litigation firms, who prepare every case as if it's a mammoth case. And I'm telling you, ladies and gentlemen, it's not good enough. You've got to find ways of adapting your procedure to the kind of money case or issue case that you have before you. And I mean it very sincerely. You've got to be adaptable. It's no good spending thousands of dollars on a case that is only worth at the very maximum $20,000. One of the problems that I have, which is why I'm a great advocate for case management, I get a case just before trial. There's $8,000 involved. Both law firms have rendered bills of over $6,000 each. So that is why I'm an advocate of early judicial intervention. And that really is the big justification for the unbelievable effort that we are embarked on in case management. Case management is relentless. I do it every day. I clean them up at night and I come back the next day and there's another group. And I must say I find them very difficult. I have several scenarios to discuss with you. One of them, Miss Kennedy, without knowing it, kind of took from me, and I think I'm going to get rid of that one to start with. The last one that I was going to discuss with you was the procedure in this area used by Mr. Justice Farley. I have in front of me the practice direction concerning the commercial list. Dated March the 22nd, 1992, you can get it, and if you look at number 50, you will hear about the procedure followed in that court. You will hear about an informal compendium. Probably wonder what that means, but it's there. And it's well worth reading. In appropriate cases, to supplement any required formal record, counsel are required to consider preparing an informal compendium of the key materials. Then it talks about authorities, it talks about a fair extract of documents. What that means is they don't want a 100-page trust document put in front of the judge with no indication of where the important clauses are, and that leads them into highlighting. I discussed this matter this morning with Mr. Justice Blair, who tells me that he's the good guy of Farley and Blair. And he tells me that this procedure is absolutely key. And I recommend that if you do have a big document case in the ordinary court and not in that commercial court that steals all our better judges, and really does, I mean, absolutely wrings us dry from time to time, which quite frankly is a problem, and I don't mind saying that to Farley. They take too many of our judges. I'm also part of the commercial list. But I think that if you have a big case, then you might well follow the Farley-Blair style of dealing with it. The judges like it that way. Now, let me look at my scenarios. The first one arises out of a case managed file. It arrives on my desk in my chambers, attending counsel come. It's usually at 9 o'clock in the morning. It can be a small case, it can be a big case. My immediate job, I feel, is to produce a settlement. Let's assume I can't produce a settlement for some reason. Stubborn lawyers, stubborn clients, my inadequacy. So then I say to myself, what's the next thing to do? Let's have a discussion regarding a trial date. That immediately leads us into a discussion of time and how long the case will take. Very often then, I have an opportunity to discuss issues. People will tell me about how many witnesses they've got and where they're going to come from. Often, if we have a dialogue, and my whole style and all the meetings I have in chambers is to get a dialogue going between counsel, because that normally leads to some kind of result. So we discuss witnesses. I do an enormous amount of personal injury work. Quite often, too many doctors are called. They really are. You don't need them. Lawyers sometimes think they just have to call everybody. Too many reports, too many doctors. We get a discussion on that. I always raise the question, if it's a document case, of agreed document briefs. It helps a judge enormously. And if a counsel stands up and files a document brief, he immediately looks golden, I can tell you, in the eyes of the judge, particularly if the other lawyer has got a bag with loose documents in it. So make that absolutely mandatory. And have a meeting with the other side ahead of time if you can. And this is why I've mentioned that there are some cases that just have to be settled because they cannot stand the kind of preparation that they need. Read the rule with respect to admissions. The number of lawyers who get caught by being in breach of Rule 5103 about admissions is just unbelievable. And then they have to ask the indulgence of the judge to get around the rule. And you look bad as a counsel when you have to ask the indulgence of the judge. You've got to look professional. Always have backup positions as a counsel. Always have a backup position. If you're not going to win on this point and you think this scenario may develop, be ready to make some suggestion to the judge. Have many pieces of equipment with you so you can use them. Try to think what is going to happen. I always used to say that the program counsel was the worst counsel, really. It's the counsel like Harvey Bliss, because he doesn't always know what he's going to do. And that makes him a dangerous counsel, and I say that sincerely. But know about how that rule about admissions works. It's very important. We'll talk about the trial date. Invariably, when I talk about the trial date, I can get back to resolving issues or resolving the whole case. A constant problem in personal injury cases is the fact that many counsel in this town have no intention of ever taking the case to court. I was going to refer to them as Danforth lawyers, but I'm told that gets me into trouble. So I'll just refer to lawyers who hope to settle the cases, and then at the last minute, they get caught, and they send the file down to these well-known personal injury lawyers. Personal injury lawyer counsel looks at it, he finds that prayer for relief isn't good enough. So immediately, he wants to amend the prayer of relief to increase the amount. So we're into all kinds of trouble. I usually use that as an opportunity, particularly if I know that a lawyer really doesn't want to send the file out, and this is a motion to amend is a kind of a last attempt. I can often get the case settled. When you start amending at the last minute, believe me, you look lousy. Make sure that you go through your pleadings and see, because very often you've not drafted the pleadings. I'm not particularly impressed by the school of counsel who comes in the last minute when someone else has done all the pleadings and he just does the trial work. I'm just not too keen on that. I believe that counsel should know what's in the pleadings. I'm one of those civil judges who keeps a copy of the pleadings and the rule book on his desk, and I keep it there all the time. When I do criminal work, I had a little piece of advice years ago: always keep a copy of the criminal code and the indictment, and watch. Try to make sure you can follow the evidence against the indictment. And with the civil work, watch the pleadings. Make sure that what is coming out is within that framework. Jury trials. Very serious problem with us. They take far too long. I have been trying to shorten jury trials. In the last 3 years, I think jury trials have gone on far too long. Piece of advice for you. I tell all the judges who work for me, or work with me, they tell me rather than for me in Team 4, that if they want a mid-trial, pre-trial, they can always have it. I'm always prepared to discuss with counsel in chambers who does that. For example, if I've got a serious personal injury case, I'm not going to give that to some judge who might be working with me, but real experience is sexual assault cases. I try to match people up because I find it works better that way. And often I might say to you, I've got 3 judges here. They're available. They do a mid-trial, pre-trial. Tell me which one you want. I'm not sure I meant to do that, but I do it anyhow. And I find it very effective. And another thing that you lawyers should do. Some lawyers tell me they don't care who they appear before. I think that's asinine. Always know who the judge is. Learn as much as you can about who the judge is, because judge's background always means a lot on a case. So if you want a mid-trial, pre-trial, let us know. I also do a fair number of motions under Rule 37. Now, Rule 37 is the rule that is used to case manage a file that isn't one of the lucky 8 or 10 or whatever it is. It's really a babysitting job. I use that all the time on big cases, and I find I get a real knowledge of the case, and I find that I can effectively control a great deal of what goes into the case. I've just got another big one now, and the last 3 I've done, every one of them is settled out. Often we have meetings, we discuss a witness is going to have to come from Germany, and then you get into a dialogue. Does the witness really have to come from Germany? And then sometimes you come up with an alternative way of dealing with it. Sometimes you end up with a recommendation that you use ADR or some kind of arbitration. The way litigation is being conducted today is completely and utterly different than the way it was conducted 30 or 40 years ago. There will be a judicial involvement, whether you like it or whether you don't. Our bench, Mr. Justice Campbell, who's just taken over from Mr. Justice Traynor, who is retiring to Gore Bay, he tells me, is completely and utterly committed to pre-trials. I believe the bench, to some extent, hasn't been as good on pre-trials as they should. I think all of us have dealt with judges who say, well, you're too competent counsel. Why on earth should I be able to help you? Would you like a trial date? Well, I can tell you that is the wrong way for a judge to conduct a pre-trial. And quite frankly, if I hear a judge does it, I do occasionally, I usually have a word with him. The Chief Justice is committed to pre-trials. Getting an early pre-trial is, other than case management, is much easier said than done. It's very difficult. It can be done, particularly if you know your way around, and one of the virtue of having years at the bar is you learn to know your way around. Pre-trials, I find incredibly effective. I sometimes have 2, if not 3. Sometimes I will set an all-day pre-trial in July, particularly if it's a big case. Sometimes I can sense that a case is going to settle, and I ask for the clients to be present. Sometimes lawyers will ask for the clients to be present. A pre-trial, a lawsuit is a moving object. Things are happening in it all the time. You're not going to be allowed just to bury your files. Your files are going to move along, and you've got to move with them, or you'll have to move out. It's really as simple as that. I like to be able to have dialogues with counsel at meetings whereby we can sensibly review the case. Years ago, I knew some lawyers who wouldn't discuss settlement because they thought it was a sign of weakness. Those days, ladies and gentlemen, have gone. Most of these cases can be resolved. I urge you to try to resolve them at an early stage before the cost consequences become out of hand. I don't have to tell you that. And I don't really have anything more to tell you other than you should get a copy of that practice direction from the commercial court. I would welcome a couple of questions if anybody would like to ask me a question. What about you, McCarthy? You're always very talkative when you come to see me.
I don't have any questions.
Do you agree with what I've said today?
Absolutely.
Well, has anybody else got anything to say? Miss Kennedy, how do you prepare a $30,000 case, or don't you? How do you get rid of a small case? I'm being absolutely serious. Now, I think you're in a biggish firm. How do you deal with small cases?
I think what you have to do is you have to really think about settlement right at the beginning.
At the beginning?
Absolutely.
So you agree with me, this business of waiting. And this leads me into another problem. In the days when Harvey and I used to litigate in the early 60s, didn't we used to have settlement meetings after discoveries, Harvey?
Automatically.
Well, why is that gone?
I don't know. I think a lot of it is the necessity of dockets. I think it's to some extent was discussed earlier, a large firm syndrome, the need to docket.
I think that's partly true, but I think there's another reason. I think it's called a cop-out. I think there are lawyers like to be able to say that a pretrial judge has made a recommendation. Justice Koo and I have often discussed this, and we regret the fact that many cases do not get settled until pretrial. We think it's a bad thing, and we really think that everybody here should try very hard to try to settle the case early. What do you think, Harvey? Do you think they should try to do that?
I just settled a case before discovery.
Well, that's the way we used to do it sometimes in the old days. I can remember when Ken Howey did defense work, which is a very, very long time ago. I remember on an appropriate case, he'd be over in your office right at the beginning. or people from the Lavinda firm, see you right at the beginning. So you think that some of the delay is docket-driven, eh?
Case has to be ripe for settlement.
Well, I like some dialogue on the subject of dealing with cases early. One of the things that really disturbs me is case starts. Very little effort seems to be made to cut it off at the pass. You know, it starts to roll along. And then suddenly you've got it out of hand. I think cases fall into categories. I think that if you have a commercial case where maybe there's $20,000 or $30,000 involved, there are two viable companies, I think maybe it's worth a meeting with the parties to see if it can be resolved. Business people don't like spending time in court. Sometimes you have to let a case cool down because the parties are mad at each other. There are commercial cases. I think most of them can be settled. Then there are cases involving people who are paying legal fees out of their own dollars. Some of those cases, they cry out to be settled too. But I think if I do have a message for you, try to identify the cases that can be settled early and settled quickly. I'll give you a little tip there. I remember I had a case many, many years ago, and I got a telephone call from the late, what was it, Andy Bruin, who you probably remember, don't you? And he phoned me up, and he always called me Mr. Lissaman. I was about 30. He must have been 60. He called me up and said, would you tell me what you will take? Settlement figure, please, Mr. Lissaman. So I called him back the next day and said to him, Mr. Bruin, here's my number. There was a silence at the end of the phone, and Mr. Bruin then said to Mr. Lissaman, Mr. Lissaman, I thought I asked you for a settlement offer, not a capitulation offer. And it's no good, you know, giving a figure that is 99% of your claim. You're not going to settle the case. Just not going to do it. Does anybody else want to ask me anything? A lot.
Repeat the question.
The question is, how much attention do I pay to an early offer? I think I pay a lot to that. Do you mean after a trial, or do you mean at a pre-trial? I think I pay a lot to it because I think it gives me a message. It tells me that that particular client is reasonably serious about it. Yes? I see nothing wrong with that. I'm seeing it more and more. I think it should be done. Let me ask you this, and I don't want any names. Are you people satisfied with the kind of pre-trials you're getting from the bench today? I'm being absolutely serious. Well, I know that, but I mean generally speaking. Well, I'm going to convey that back to the Chief Justice. I anticipated you'd tell me that. Yes, sir.
Problem's a long wait till you get a pre-trial. One case, it's almost 3 years.
Well, that is a terrible problem, and I shall communicate that to the powers that be. Yes, sir.
I practice in Thunder Bay, so the situation may be different there, but there's a real problem with the pre-trials in terms of the quantum. I've had two cases recently where the number was discussed at a pre-trial was 60,000, and it ultimately was resolved at 300,000.
Was this a personal injury case?
Yeah. We had another one up there that was, the number at the pre-trial was 500. It was settled at trial at 3.4 million. There's too much.
I didn't think you had that kind of money up in Thunder Bay.
Mr. Justice Laskin came up to the problem. The fact is that there's too big a gap there. There's too much inconsistency. I had another trial where at the pre-trial judge said that I was going to lose on liability, and the jury awarded 900,000. So it's really hard to settle cases like that at the pre-trial. I don't know what the answer is, but there's something wrong there. Maybe it's the inability of the judges to deal with these issues.
Well, if have you been to the advocates panels on personal injury awards, where you often see 10 particular people and their awards are all over the lot? You've seen that, haven't you?
But I'm just saying this is one of the problems with settlement and pre-trial.
I find on personal injury cases, I find that today the general damages is not much of a problem. I find the real problem is with the loss of income and loss of futures. Now, what about you, Daniel? You do a lot of this work. Do you find that problem?
Yes, I find that that's one of the areas, and I think it's the individual judge is a big part of it, but and if the memorandum is detailed and you've got your actuarial reports and you can hone in on the issues, it can help to get the parties closer in the numbers. I haven't noticed the same problem to the same extent here in Toronto.
Well, I don't think I've seen the problem like that here at all. I'll tell you another thing I do often at my pre-trials. I sometimes try to get rid of the jury notice. As many of you know who practice in Toronto, here the jury notices are served by the defense bar, and which is quite unique, really. And I often feel that a non-jury trial will be much quicker than a jury trial.
Do you treat the pre-trial differently if you know that both parties or one party is publicly funded or on a legal aid certificate?
No. No, I don't. Should I? No, I don't.
You were saying that you were looking at if the claim is, for example, $10,000, and you asked both counsel what they spent, and you say they spent $6,000. Each of that total is $12,000. Do you take that into consideration more so against the $12,000 coming out of the taxpayers' money and there was no payback?
Well, let me answer this. I was pretty quick to give you my reply, but I do have cases where sometimes I see a plaintiff who doesn't have much of a case, who is funded by a legal aid certificate, and there is a defendant placed in defending that action with no hope of ever recovering any costs. And sometimes I might say to that defendant, look, make a reasonable offer, because if you don't give it to the plaintiff, you're going to give it to your lawyer. I certainly do that from time to time. I also wanted to remind you of the Court of Appeal decision, which I'm sure Ms. Kennedy knows, but I don't have the cite, that says that a motion to strike out a jury notice must be brought by the parties. Until the Court of Appeal set us straight, most trial judges, me in particular, I always thought that I had the right in my residual powers to strike out a jury notice. Well, the Court of Appeal tells me that I don't. So you might remember that. And if you ever want to get rid of a jury and you feel that the judge wants to it, then you better bring your motion. I might look very hard at you and send you a code message or something like that. But you have to bring a motion. Yes, madam.
You were talking about people don't seem to settle early. I think that the real difference from when you were practicing in the early 60s is that we don't know each other anymore. And I come to this group of 250 people and I might know 3 people. And you gentlemen used to know each other and you probably go on the phone and sit down and have lunch together.
There's some truth to that.
And people don't do it anymore. I've even noticed a difference in the last 10 years.
I think there's some truth to that, and I think in small Ontario County towns, people still know each other pretty well. Yeah, that's a good point. Yes, sir. Anybody else got any questions?
We have no speaker.
Thank you very much, Harvey.
Thank you. It's very useful. Frank talk from a good judge. Our final speaker today is Bob Armstrong, fresh from the trial court, gown on, to talk about production.
Well, I've just done something that I've never done in my life, and that I'd shoot a Junior for doing on the spot. I've left my witness in the middle of cross-examination. He's going to be cross-examined, I'm told, until 4:45, and I'm going to go back and re-examine him without knowing what he said in the last half hour. But I have somebody there who may tell me what he said, if anything. I've always been able to adopt the approach in these Law Society lectures of not giving 2 lectures. The practice, I realize, is that you deliver a paper that gets circulated to everybody in advance, and then you come and give a completely different lecture, so you look intelligent and you live up to your advance billings. The way I've been able to finesse that in the past was never produce the paper before the lectures, but our chairman, Harvey, Bliss, finally threatened to report me to the Law Society for conduct unbecoming or failing to answer his telephone calls or whatever, and he did get a paper out of me, as it were, and because I've been involved in a trial since March the 8th, and I don't know anything other than what is going on in that trial, and most people who are in the trial would say I don't know anything that's going on in that trial either. I haven't prepared both a paper and some extemporaneous comments on this subject of production, so you'll forgive me, but I won't read every word of it. I make the point in the opening sentence that the only task in the conduct of an action which is more tedious than assembling your client's documents is the task of ensuring that you have production of your opponent's case, and I suppose I should add to that probably the only task more tedious than that is having to listen to Bob Armstrong talk about it. As I've suggested in the paper, I wish that I sat down one weekend after Harvey asked me to come and speak on this subject, and it is a terribly important subject, and I said to myself, you know what, for the younger lawyers and for those who are old and tired like me, what are the kind of 2 or 3 sort of catchy, helpful hints that I can pass on, and that maybe you'll go away, as it's said often in respect to these continuing education lectures, that they're worthwhile if you just take away one idea. I'm afraid that I came away dry in the sense that there really is nothing new under the sun in terms of document production. I do, however, make the point in the beginning of the paper that I want to emphasize, and that is that my own observation, which you may say is wrong, and if you do, you'll probably be right, but my own experience over the last several years, I think with the advent of the Xerox machine, and probably, although most of you are younger, and you'll see I'm showing my bias, but maybe with the advent of the computer, that not enough thought now is given to production. And if anything, I think what we're seeing is overproduction. I think people are just mindlessly photocopying documents, cataloging them by date or whatever, throwing them into an affidavit of production, or worse still, not even putting them in an affidavit of documents, simply throwing them into documents books and delivering them to the other side. And as I've suggested in my paper, there really are 2 extremes. There's at the one extreme, there's not nearly enough production. At the other extreme, which for my mind is worse, having too many documents to read. And while it now is a task, of course, that particularly in the big firms in Toronto and the smaller firms with all of the sophisticated support staff and helpful equipment by way of computer and others that is available, the tendency is to delegate, and indeed the tendency seems to be to delegate to law clerks and to secretaries I suggest you ought not to abandon the task. And too often, my observation at least is, rightly or wrongly, that lawyers, particularly the old so-and-sos like me, are abandoning the production task and not staying in touch with it. And it is really, in my view, one of the 2 or 3 most important things we do as trial lawyers, the production process, both in terms of producing our own clients' documents and the subject that I'm here to talk about, ensuring that you're getting full production from the other side. And often that task itself is delegated to a junior, to a law clerk, all of whom are very bright and very able. But, you know, if you're the person responsible for the case, you're the person who should be calling the shots, who should have the most experience in relation to what the issues are and what it is you should be seeking in terms of documents. And you ought not to be doing what some of us sometimes find ourselves doing on the 3rd day of trial. A document gets produced in the middle of the trial, and you turn to somebody and say, where the hell did that come from? And they say, well, you know, it's document number 7 on the Affidavit of Documents. And in any event, in my suggestion to you, stay involved in it, and particularly as you get older in this game, for the younger members of you, you don't feel that that's one of those tasks that you can simply leave and never have a part of again. How do you go about the task of obtaining production from your opponent? Again, I apologize for talking like an old man here, but Harvey will, I'm sure, remember, as will others in the room, that there was a theory that abounded not that many years ago, and in fact it was a theory and practice that was accepted by, to my knowledge, virtually a large number of lawyers in one particular county town, which I won't name, and that was the theory that you only had to produce those documents upon which you relied. And it was a completely sort of foreign notion that if your client actually had documents that hurt your case, that you wouldn't produce them. Now that presumably will surprise 99% of you in this room, but it wasn't so long ago that a senior lawyer in this province, an examination for discovery that I had, quite frankly, took that position. I'm not, the only documents I'm producing are those documents that help my case. And, you know, those of us that do a lot of defense work, you've got to press us and press others to make sure that, of course, you are getting all of the documents that are relevant to your case, and you, in my view, ought to take full advantage of what the rules now provide. What I still call the new rules of 1985, of course, provide a broad kind of code of practice that should enable you to get every single document that you require. There are, of course, 2 views of those rules. They were promulgated at the time to lessen the cost of litigation. One thing they did was they certainly increased the cost of Xeroxing, photocopying, and so on, and some of the downtown law firms now have their Xerox or photocopying operations as major profit centers as a result. But nevertheless, the rules, and that's why I was kind of perplexed when not only did I agree to deliver this little talk, but in fact, Harvey was kind enough to give me 2 or 3 choices, and I was stupid enough to pick this particular topic. And when I really began to think about it, I came to the conclusion, well, you know, it's all in the rules. And it is, starting, of course, with the definition of document in Rule 30.011A. A document includes a sound recording, videotape, film, photograph, chart, graph, map, plan, survey, book of account, and information recorded or stored by means of any device. And, you know, we as lawyers should not be immune from going back to sort of starting from scratch, and don't assume, for example, as I've suggested in the paper, that you know, that the other side has paid particular attention to the broad sweeping definition of document. And when you attend on examination for discovery and get into the issue of documents, make sure you ask questions that are as broad and as sweeping as the definition itself. I've been in at least one case where indeed it was a real estate transaction that failed to close, and it ended up both law firms getting sued, and the vendor and purchaser being sued, and so on. And it eventually came out, but it was a while before it did come out during the course of examinations for discovery that the lawyer for one of the parties, solicitor for one of the parties, had indeed recorded every single telephone call between himself and the lawyer on the other side. And there was a complete record of the entire discussions that took place between the lawyers. Now, I eventually got that out on discovery, and I'm sure I just fell into it. I wasn't even smart enough then to ask a question like that, but the trial really proceeded on the basis of this recorded evidence, and in fact the whole case was determined on the basis of that evidence. You may say, well, so what? I just tell that story because I think you'll find that indeed a lot more people record telephone conversations, for example, than you and I may think. And having accepted that, you may say, well, so what? I think a lot of people, more people record telephone conversations than you and I may think, and I think there are a lot of people who may not tell you that they do, including your own client, for example. You know, don't be afraid to pursue that kind of information, and of course the rule gives you full opportunity to do that. The next point that I make in the paper is the Affidavit of Documents itself, and of course for a number of us, we hate doing Affidavit of Documents. I mean, it's only the Harvey Blisses of the world that just take great pleasure in producing these long and detailed affidavits of documents, and most of us in a number of incidences are happy and content to waive the Affidavit of Documents, and this is a sort of case of my telling you do what I say, don't do what I do, because I do waive the Affidavit of Documents more often than I'm prepared to admit, but I shouldn't. You know, there are small cases and cases where there are unlikely to be very many documents where you will waive it. And you know the lawyer on the other side, and you trust her. You've got a sense of the party on the other side, you trust her, and so you say to yourself, fine. Well, if you've got that kind of confidence, I wouldn't complain about that. But increasingly, of course, we are getting into these big documents cases. Big by, I mean, many numbers of them. And I think it is important to require your opponent to go through the discipline of preparing an affidavit of documents, requiring his or her lawyer to put that person to the discipline of what are the relevant productions, and requiring either the officer of the corporation, or where it's a personal party on the other side, requiring that party to give his oath, as it were, or her oath, that these are all the documents. And of course, I think it's equally important to require the solicitor's certificate that is provided for in the Affidavit of Documents. And then I think you have a fairly high comfort level, because quite frankly, if I get an Affidavit of Documents from Harvey Bliss and it's got his certificate on it that he's performed his obligation, then I know at least that he's done all he can. He's sat there with his client, told her, him, what the obligation is, and I have no doubt that in a complicated case and in what is a purely documents case, that by requiring your opponent to go through that process, that you are going to get better production. There is just no doubt about it. The next topic that I raise is the topic, for lack of better terms, identifying gaps. And I say once your opponent's Affidavit of Documents arises, this is, of course, a penetrating glimpse, or perhaps not a so penetrating glimpse into the obvious, but send the Affidavit of Documents to your own client and arrange a meeting with him to review it. It's surprising, again, how many of us don't go through the discipline of, when we get the affidavit, sending it to our client with a letter saying, here's the Affidavit of Documents. It's the same sort of affidavit that you've been required to do yourself. I want you to review it. You're familiar with the business involved here. You tell me whether you think there are any areas that the other side has missed, and make an appointment, if it's a complicated case, for that purpose alone. Again, do as I do, or say not necessarily as I do. Like all of us, I often find myself in the position of, the day or two before discovery when the client comes in. We sit down and start reviewing the Affidavit of Documents, and he says, oh, well, I know I did one of these. I didn't know the other side did it, and what's all this about? Perhaps being a bit tough on myself, because I do pay attention to that sort of thing, but just it's a simple thing, and my advice is to do it. Another useful approach, again, rather obvious, but in these big cases, whatever the issue is, it seems now one usually has, unless it's a purely contract or purely commercial case, one has retained an expert, and take advantage of your expert's expertise, as it were, not only for the purpose of providing you with a report with a view to him, with a view to him or her testifying, and with a view to helping you cross-examine opposing witnesses, but send along both your opponent's Affidavit of Documents and your own, and ask your expert for his or her advice as to what gaps, in fact, he may perceive there to be in the production. He, from his perspective, as to what may well be missing, or from his perspective, he's probably in a very good position to identify gaps that perhaps neither you nor your client would readily recognize. And then I make the obvious comment about, review each of the documents carefully, and it's, in terms of what the attachments are, what the referenced enclosures are, and so on. And, too often, again, laziness sometimes takes over. The other side will produce a letter, and you'll see down below the word NCL, and you won't ask if the other side has the enclosure, or you think you know what the enclosure is. Get them to produce their copy of the enclosure, and get them to produce their copies of attachments and so on. don't just simply accept, well, you know, that what was enclosed in the letter of January the 5th was a copy of the bylaw of the corporation, and you've got 15 copies of it. What you want to see is their copy to see what notes they have made on it, because that's where, of course, you get a lot of hard information that you might not ordinarily get. Then, in respect of cross-examination, there is Rule 3006 where the court can, in fact, order cross-examination in a particular circumstances, and you can bring a motion in to permit it. As I've indicated, in my experience at least, I haven't taken advantage of that particular rule. Now that under the 1985 rules you can cross-examine on an affidavit of documents, which you couldn't do. Some of you aren't now out as many as 8 years, so the new rules aren't new rules at all. They're the rules you've learned in law school and grown up with. But until 1985, you couldn't cross-examine on what was then called the affidavit of production. And of course, there were always great fights and discoveries when you got into a particular document, and somebody like me would say, you know, I'm sorry, you can't ask those questions. That's all cross-examination on our affidavit of documents. And the Rules Committee saw through all of that fairly, well, I was going to say fairly quickly. They didn't. It probably took them 50 years. But they amended the rule in 1985, and now, of course, you can cross-examine on an affidavit of documents on discovery, and, of course, you should do that. And I know Patricia Jackson and others were here talking about discovery. See, Harvey also has got a paper in this area, so I'm sure you are now much wiser than I could make you on the whole issue of cross-examination on the affidavit of documents. But certainly in my practice and in my view, in a documents case, the examination for discovery and the cross-examination on the affidavit is an essential part of your case, and as I've suggested, you should review your opponent's record-keeping system and indeed the process whereby she went through the compilation of the affidavit of documents, because with the best will in the world, Harvey Bliss may have sat his client down and said, this is what you have to do to produce your documents, and you have to look everywhere, you know, in the bottom drawer, top drawer, under the bed, under the mattress, and you have to produce everything that you have that's relevant, and I want you to go back to your office and do that, and then bring it all in here. You'll probably find, in some cases, that indeed Harvey's client hasn't done that. Or your opponent's client hasn't done what he's been told, and you may well find that there is a record-keeping system that is such that will lead to avenues of discovery in respect of documents that the client himself said he hadn't looked at. And I find it with my own clients all the time. Oh, geez, I never thought I had to kind of look in that file. You know, it'll be a file with a label on it that says liability in A versus B, and that's the very case you're in, and he'll say, oh, geez, I didn't think that was at all relevant. Probably isn't, because it's relevant, but it's privileged in this case. But, I mean, you'll be surprised. In fact, with the best of intentions, your clients just don't always understand. At least mine don't, and I assume that my opponent's clients don't understand. And so that's why I spend some time in the examination for discovery in reviewing the record-keeping system. Finally, I raise in the last section of my paper the obtaining of documents from third parties and related corporations. I've set out what the rules are there. Again, some of those are 1985 amendments, and before 1985, those of us that were laboring away in litigation were always under the handicap of, you know, how do we get documents produced from non-parties? How do we get documents produced from a subsidiary corporation? Harvey, after the lecture, is probably going to tell me those amendments have been in the rules since 1956 or something. But anyway, they are all there now, and they've clearly been there since 1985. And they, again, are useful rules to bear in mind and to pursue to their fullest. Finally, I've suggested in the paper that if, of course, all else fails in terms of document production, you can, as a last resort, serve a summons on a witness pursuant to Rule 53041, requiring the person named in the summons to produce at trial documents or other things in his or her possession, control, or power relating to the matters in question and the action that are specified in the summons. And, again, with the way the rules are structured now and the broad avenues of production and discovery that we have, that rule doesn't get used very often, but it's a good one to have in your hip pocket. And, again, my experience is, certainly when it's used against me, that if somebody from my client's corporation all of a sudden has a summons to bring a boatload of documents, I am convinced fairly quickly, or my opponents are convinced fairly quickly, to go back and take a sober second thought at what it is that is there that they may want, and in 9 times out of 10, or indeed 99 times out of 100, I find that it's not necessary to carry that rule through to the actual implementation, but it's an effective device, although I'm prepared to agree that in this day and age it's not necessary in most instances. Those are my comments. I apologize for coming and speaking out of order. I thank Harvey for letting me come to speak out of order. I had offered in my place my partner, Patricia Jackson, and Harvey's first reaction to that was, well, I wouldn't inflict a paper of yours on Patricia Jackson to have her come and read. And she said she'd come in any event, but then she read the paper and she said, no thanks, you better show up yourself. So I've come and shown up myself, and I thank you for your kind attention.
That's the end of the program, save for questions. Does anyone have any questions about any part of the program today? Thank you. Those of you who did not pick up the late arrived papers, remember they're at the desk. Thanks for coming.